My name is Robert Zink. I'm the acting principal deputy chief of the Department of Justice's Criminal Division Fraud Section. I have the pleasure and honor of serving under Sandra Moser, who is the acting chief, who you heard from yesterday. The first item up for bids today will be a hypothetical fact scenario. We'll be working through a potential FCPA, accounting fraud, and export controls problem this morning together, resorting to panelists on 2 expert panels. We will delve into the facts, analyze the issues, and see if we can reach some legal conclusions or at least some heady legal advice.
We have worked very closely together with a wide group of people to bring a scenario to you, a hypothetical to you, to discuss and to really bring out issues as they appear and as they complicate situations around investigations. We probably all know that when you start an investigation, facts are uncertain. You don't know how big it's going to be. You don't know how to manage the client yet. You don't know how to manage the costs yet. And you have no idea which regulator, if any, may become involved. And so we're trying to explore that a little bit here. The hypo has deliberately been drafted by a non-lawyer. I always find that when you get lawyers to draft these hypos, they're ever so clever, and it all matches together very nicely. This one works very well, I think, but it isn't a typical lawyer's hypo, and I hope that that will generate some discussion amongst us all. This isn't really us talking to you. I very much hope that you'll all bring in your own knowledge as well and your own expertise, and do feel free, please, to ask questions as we go along. I'll introduce my panel now, but let's move first of all to Louise next to me. Louise is an associate at A&L Goodbody. She's in the white-collar team in Dublin. Prior to her move to Ireland this summer, she spent 3 years as a principal investigative lawyer in the SFO's Bribery and Corruption Division, where she was on the other side of my table very regularly. I'm sure we bonded over that more than we'll bond over this. Before that, before her time at the SFO, she spent 10 years working in both private practice and in-house roles here in London. And then one beyond Louise, we have Charles.
Paul.
One beyond Louise. Oh. Sorry.
Oh, no, sorry.
I'm going down my list. Sorry, Paul, I'll come to you. You get the honorary last place. Charles Ross-Stewart is a solicitor and regulatory compliance specialist. He has extensive experience, which you will all hear from, in both private practice and the banking industry. He started his legal career at Freshfields and moved in-house in 1994. And in 2009, he became the General Counsel for UBS Investment Bank, EMEA, and then moved to Citigroup in 2012 as the Chief Compliance Officer, again for EMEA. Charles is now working as a regulatory consultant, currently assisting the Bank of Montreal in, yes, guess what, their preparation for Brexit. There must be quite a role out there for something like that. So thank you very much for joining us, Charles. We know you're extremely busy, and we're very grateful that you're here. Finally now to Paul. Paul Doxey has a day job and a night job. His day job is as a forensic accountant with Charles River Associates in London. Paul spent 14 years in the financial services practice at Arthur Andersen until Enron put paid to that in 2002. He worked for over 2 years on secondment in the Special Investigations Units of the Bank of England and the Financial Services Authority. And he now focuses mainly on forensic accounting, investigations and expert witness work, for example, leading the accounting investigation for the SIPC trustee, Irvin Pickard, into the Byrne Madoff UK operation. But more interestingly, and that is really also why we have him here, is his night job. He has a sideline in the digital management of information. He has founded an early-stage startup that has developed radical approaches for simplifying the management of information and documents, while improving quality and usability. And it's one of the areas that I'd like to talk about, because very often in the course of an investigation, so many documents are generated. Investigations last many years, prosecutions can last many years, and sometimes it's not easy to place your hands again on that document that you drafted very early on that explained why you went to certain custodians, why you went to certain witnesses. And one of the very clever things that Paul has done is help devise a program that would help law firms, accounting firms, to manage the documents generated in those large investigations more usefully. Robert has introduced himself. He is the acting Principal Deputy Chief, U.S. Department of Justice, Criminal Fraud Section, working under Ms. Moses. So thank you all very much. We will move on to the hypothetical. I don't know whether any of you have had the chance to read it. We did try to keep it to one page, but still there were quite a number of words, and it wasn't all that easy to follow. So let's go through a little bit of the scenario now to give you an idea of where we're at. So I am the General Counsel of Sparkle. It's a London-listed manufacturer of, let's just focus mostly on the drones and the related stealth technology. The company has operations in the UK and Germany, and in the last few years it's branched out more particularly into drone technology, and it sells white label goods to other manufacturers. I work in a company with a global customer base, recently started building operations in Eastern Europe, Turkey and the surrounding region. It's particularly Turkey that we'll be focusing on. The company has obtained export credit finance from a number of European agencies, including the UK's Export Credit Guarantee Department, and it's there, the money is there to assist us in establishing export markets in the region. And you will see in a moment that we've deployed some of that money to further our business in Turkey. I have been told via email of an anonymous whistleblowing report of irregularities in relation to the use of the export finance funds. And it's alleged that loans that have been made by the company to a local supplier have been diverted to its owners and may have then been distributed onward to unnamed third parties. So as ever, this is all we know. Right now, the added information that is worth knowing as well is that I am in the process of selling and working with US counsel to sell the company to a US entity. At the moment, as we mentioned, we're only listed in the UK, and we have operations manufacturing in the UK and in Germany, but we are widening out our markets, particularly into Turkey. But now we also have the widening net of the jurisdiction of the US. So I have an issue. I have lots on my plate, and my background is in corporate law. I don't do this. I don't understand it. I've never been in this situation before. I make some internal inquiries, and I learn that the business unit involved has conducted a brief initial inquiry to follow up on the allegations. And I explain all of that, which is really all we know, to my external counsel. And I make sure that I have my UK counsel, Louise, and I have my US counsel, Rob, on this telephone call, and I keep very closely to Charles, who's going to help me with the internal situation. So first of all, Rob, I've asked you to join this call, just to be in the background of me, please, because we, of course, have the sales situation going on. But first of all, if I can start with you, Louise. We've heard that the company has received monies from the UK Export Finance. We've used some of that money, and there are now allegations that that money has been misused. What do I do next?
Well, this is where you get to make your sort of really, really early risk call, because your first and initial actions on this are probably going to set the tone for the rest of the investigation or whatever might come after. At the moment, all you have are quite vague allegations. And you need, first of all, to establish control. I mean, at the moment, you've got an internal business unit who's gone out and conducted an internal inquiry into a whistleblower report, and you didn't know anything about that. And so as a GC, I think you need to try and regain control over the facts and regain control over the situation. You need to shut down whatever the business is doing by itself, and you need to get a handle on what's happened. That's your first step. I don't think at this stage, and I mean, it's debatable, but I don't think at this stage you'd be going running to anyone to report this, because it could be nothing. It could be, as someone was saying, fake news. You know, this might not amount to anything. At the moment, you've got an allegation, and that's it.
Charles, would you agree with that? do I hold this close to my chest at the moment and
Well, I think the
not
first,
talk to anyone?
yeah. So I think the first thing is, the first question that this arises is, why are you only finding out about it now? So as GC, I would think you would probably want to be aware of these things at a much earlier stage. But that's kind of crying over spilt milk. I think that the main point is that any form of whistleblowing for a company, which is obviously an established, decent-sized company like this, they should have their internal whistleblowing procedures. There should be, and certainly for financial companies, which I recognise this is not, but financial services companies, you're required to have whistleblowing procedures, which you have to advertise to your staff, and everyone needs to be made aware of, etc. But you should have, part of those procedures will require the departments which are involved in the process to escalate appropriately. And so that's why I would have said that certainly as GC, under those procedures, I would expect that you would have been informed in a normal situation. The question, though, is, first of all, who do you need to escalate this to, at what stage, and whether that's internal stakeholders and external stakeholders. Now, of course, with whistleblowing, the first thing is that you are required always to protect the confidentiality of the whistleblower and to provide a sort of safe environment for people to raise issues without fear of reprimand, recrimination from their management. So I think that the level that this would be being escalated to at this stage would only be very senior internal stakeholders, probably risk officer to the extent you have it, general counsel, as I said, and possibly MD or CEO. And then again, depending on the nature of the company, there may well be internal investigation department who would become involved, obviously, or if it's a smaller company, then you'd have to be starting to think about the external advice that you're getting, which I think Paul is going to help us to cover. So that's internal stakeholders. But generally with whistleblowing, obviously, as I say, in order to protect the confidentiality of the individual, but also not to kind of tip off those who might potentially be involved in any wrongdoing, the level of people that need to be involved at this stage, I would say, would be pretty senior people only, and that would be something that would be reflected in your procedures. In terms of external stakeholders, Louise has talked about probably at this stage it being too early to notify external parties, but we need to think about who they might be. So this company is, as far as we know, not a regulated company. We haven't been told that it is subject to regulation, but in the hypothetical case where there are regulators, the very first thing you need to be thinking about is which regulators do you need to inform and at what stage. So again, focusing on the financial services industry, and particularly talking to UK regulators for any kind of issue such as this, which might have a sort of conduct issue. The Financial Conduct Authority have always said that they would encourage early escalation of issues, and I think that's fairly common amongst regulators. So, as I said, this is not financial services, so we're talking about a different fact pattern, but it may be that because of the industry that they are in, that there may be other regulators, and you need to think about at the appropriate stage for escalation to those. The other thing is that we know that this company is a listed company, so there are listing rules to consider as well. So UK listing rules will require disclosure of material information at the appropriate time. It doesn't feel from this fact pattern at the moment that we've yet reached that appropriate moment for disclosure from a listing point of view. I think you would need to be more certain of the facts and have a much more clear understanding of what has actually happened and what the impact might be before you made any sort of public disclosure. So you've got internal disclosure, you've got external private disclosures to think about, and you've also got external public disclosures to think about in this case particularly. So that's just some of the thinking that I think you need to be going through at this early stage.
And so then, added to those uncertainties, I have the fact that I'm in the midst of a sales process. Rob, does that bring in any concerns from a US perspective?
I think it does. In the US, there is the black letter law of successor liability is very well established, and there may be a set of facts under which acquisition of the foreign entity exposes the successor entity, the US entity, to risk of liability. So my advice to you as my client would be fairly simple. We have an allegation, appears to be a credible allegation, we would investigate it, and once the investigation had concluded, assess the scope of civil, criminal, and regulatory liability. And at the end of the day, one of the questions I would pose to you is whether you have the in-house capability to conduct the investigation. Assuming you did not, I would advise you to hire expert counsel, foreign counsel, to investigate the scope of the allegations, the severity of the allegations, determine whether there was any veracity to them, and any corroboration for them. And after that investigation is concluded, of course, we do a fulsome legal analysis. And issue spotting based on the facts as presented today, there is the risk of FCPA liability, foreign bribery. There is a risk of foreign controls liability, trading with the enemy, and there's a risk of accounting fraud liability, falsified books and records. So the liability could be significant, but could be nothing. But the sum advice I would give is find out what happened, and find out whether there's any truth to the facially credible allegations presented.
And so at this point, I'm advised that I need to find out what happened. It is in a fairly difficult jurisdiction. We're in Turkey. Paul, would I at this point bring in outside expertise in the form of accountants, document management, or do I just, if you like, stick with the lawyers?
Well, of course, it depends. I think Louise is absolutely right. This is about risk and uncertainty, and also about establishing control. Actually, I think this question is really about triage, about what's your strategy for dealing with known unknowns and unknown unknowns. So the short answer to the question on whether to seek outside accounting help at this point is it depends on whether you feel that you've got sufficient accounting and financial expertise in-house to triage the issues. So, because in effect, triage is what you're doing at this early point. And so imagine you're a paramedic and somebody presents with anaphylactic shock. Have you got the skills yourself to deal with it? That turns on, can you correctly diagnose the problem? Can you provide the essential first aid that's needed at this point? And can you make the appropriate referral to the experts who then need to take it on in due course? And in a way, that's what happens when you receive an initial whistleblowing allegation. Your immediate need with Sparkle, with the allegations that have been made to Sparkle, is to do a kind of triage. Identify the initial issues, decide on your immediate next steps, and then develop an effective work plan. So the question is, do you have the skills in-house that you need to do this triage effectively? Often with cases like this, I might get a phone call from internal counsel, and we'll just have a general discussion. We'll bounce around ideas and issues. And the whole point of the discussion really is to help the in-house counsel satisfy themselves as to whether or not they feel they've got the knowledge and skills internally to make those sorts of triage decisions. A slightly longer answer is that, as with any investigation, what you're trying to do is get answers about known unknowns. In other words, the potential issues that you've identified already. But there's, of course, always a risk that you're not addressing all the true issues because you've missed some red flags about unknown unknowns, or at least they're unknown to you. So what are unknown unknowns? They're things you haven't thought about that turn out to be important and relevant. How can you possibly identify them? Well, sometimes you need to talk to somebody who's got a totally different perspective, because they may be in a better position to see red flags that you can't see. So the question at this very, very early stage, at the very beginning of the investigation process, is are you confident that you've got access to the knowledge and expertise to do four things? Firstly, to determine the right questions to ask. Secondly, decide on the right steps to take. Thirdly, to apply appropriate skills to whatever technical information you have to hand. And finally, to identify any new red flags. So, for example, it may be that in Sparkle's Turkish subsidiary, the interest payments on the loans it's made are not calculated at fair value. That might in turn result in the subsidiary making illegal dividends to its parent, which in turn might mean that the parent is misreporting its group profits. Now, that's the kind of issue that an accountant might be aware of, but which a lawyer may not see straight away. And a quick discussion with an expert in that field, whether it's in-house or externally, so whether it's with your finance department or internal audit or with an external advisor, that can help you unearth these red flags that you may have missed otherwise. And overlying all of this is the question, can you defend your decisions in due course to a court or regulator if things turn out badly? So how does this apply to the Sparkle case? At this early stage, you'll need to gather some basic information about things like the following. What were the contractual arrangements with the UK's Export Credit Guarantee Department? What were the terms and conditions around those transactions? What were the precise loan arrangements between Zarco and Sparkle? What were the relevant organisational functions within Sparkle that governed those transactions? Who were the key individuals at Sparkle that were responsible for overseeing those transactions or approving them? Generally, what were the key decisions and approvals within Sparkle in that area? What policies and procedures in the company govern these transactions? And you probably also want to start gathering some information about the risk management processes, the internal control structure, and the reporting processes. I mean, on the face of it, I think these issues seem fairly straightforward technically. You may well feel you've got the adequate expertise internally to deal with them. So you may not need to talk to external experts at this point, but you probably want to talk to somebody who's got a better understanding of the financial aspects and risks. All this actually raises a much more fundamental and general question that permeates the whole investigation life cycle. How do you go about deciding what and how to investigate, including how you decide when to bring in external support? And also, how do you defend the company's decisions all along the investigation cycle? And if you need to justify your actions in front of a court or regulator, how do you do that if you've missed something? You don't want to be a hostage to hindsight. I think one of the most powerful things you can do is to place your decisions within some kind of organized, systematic, and documented decision-making framework. Otherwise, it can become very difficult in future to look back and work out what were the reasons for each of your decisions along the way. And the framework can be very simple. You've got to do 4 things in that framework. You've got to keep a running issues log, basically a list of the known unknowns as they appear to you at any given point in time. You've got to relate this issues log to your information files or evidence files. You should then prepare case files which record your decision analysis, your understanding of your analysis of the evidence to relate it to the known unknowns, but also to ask questions about what do you think the potential unknown unknowns might be, or at least what areas might they be in. And document your decisions about when to bring in external expertise to help you make those judgments. And finally, you need a work plan that you execute, and in a kind of iterative way, you repeat the cycle until you're finally satisfied that you've addressed all the outstanding issues in your issues log. So that's a very simple, defensible process that you can use, which if you're challenged in due course by a court or regulator as to why you took decisions along the way, you can point to it and you've documented it, so you can explain that given what you knew at the time, you were diligent in taking what you thought were appropriate decisions.
Thank you, Charles. Sorry, Paul. I'm, of course, concerned about what is coming out, but my mind is full of the sale. My mind is full of what's happening in the States and the fact that I need to deliver this sale nice and easy, and so that we can move on into a next stage of our corporate life. It actually means that I'm distracted. But what I'm really also very worried about is the costs of going forward. I've now spoken to 2 lawyers. They each tell me that I need to investigate. I have sought advice from you that tells me that I need to be quite investigative around accounting issues. And so, Charles, asking for your experience here, how do I manage the costs of this situation? And how do I set aside time so that I can instruct my external counsel appropriately and my external expertise appropriately, and then I can focus again on the sale, whereas others do the investigation? How do I manage that?
I suppose the first thing is it slightly depends on what team you have in terms of what resources you have at your disposal within your department. and that will vary obviously from organisation to organisation. I suppose my thought would be that the potential costs of not dealing with this situation appropriately will be very much more significant than the costs of taking the right advice. So clearly you'll have to go through your internal procedures for obtaining the necessary budgets and so on and so forth for engaging external parties. But I think the message I would be giving as General Counsel to Chief Executive or Finance Director who approves those costs is this is not the sort of thing where we need to be cutting corners and scrimping on the cost. It's really, I think it's vitally important that you get to the bottom of this because of all the potential issues that we've seen that are coming up. We've not just got potential criminal activity, we've got potential accounting fraud, we've got potential bribery issues, and these are the type of issues which are very much in the headlines. So not just the financial penalties that might accrue, but also the reputational damage, and frankly, the possibility of completing on this US sale. I mean, I think a US purchaser would probably run a mile if it turned out that there was significant evidence of bribery that actually proved to be the case. So whilst you would have to go through your procedures in terms of getting approvals and so on, I don't see this as a kind of, there's no choice here. I think you have to pay whatever it costs to get to the bottom of the situation. So that would certainly be my advice to you is do whatever you need to do internally, but you have to get appropriate advice and quickly.
Pay whatever it costs. I'm sure that Louise and Rob would be delighted to hear that as I send them off to Turkey. So off you two go then and investigate for me. And we are learning more facts as we go along. First of all, that we're working with Sakko Industries. It's a local company in Turkey, supplied parts of Sparkle, and is also expressing an interest in a desire to manufacture our drones under license. The way that we established our working relationship is that we used to pay Sakko in advance. And the arrangement was that it was agreed that Sakko would receive upfront loans and that it would be repaid by supplying the components to Sparkle in due course. And these loans came out of our UK export finance funds that we've been given. But this is then the interesting bit. This is as Rob and Louise are digging a bit further, this is what they find. The loan payments were made in a cryptocurrency called Silk Purse. And Sakko said it would be much more efficient if they were to receive it that way, much better doing it that way than using the traditional banking system. Even I, as a corporate lawyer, realised that that is a bit of a red flag. It was understood by Sparkle's local manager that using this method might speed up the process of commencing the operations in Turkey, which included obtaining the required business licenses and the approvals for Sakko's new manufacturing facilities. So let's pause here for a moment. First of all, and I'll come to you first, Rob, if you don't mind, the fact that a cryptocurrency is in play here and that we have paid loans in advance. What do those facts, as you're reporting back to me, on our daily call by now, since I'm paying anyway, I may as well have a daily call with you. On a daily call, you're telling me that this is what you've uncovered. Where does this put us? Where does this lead us?
I think this, I would advise you that this certainly smells like a bribe. In my not insignificant experience investigating these types of cases as your American corporate criminal attorney, I'm unaware of situations where transactions of this nature are facilitated using cryptocurrency and booked on the company's books as loans. It's a unique set of facts, and I'm beginning to think, as I tell you, that there might be an illicit relationship.
Another situation. That there might be another situation.
Sorry, an illicit relationship.
An illicit relationship, I'm sorry. Louise, what's that illicit relationship?
You now have a fact pattern where your manufacturer has told you or your local subsidiary that they need this cryptocurrency to obtain business licenses and approvals. Now, I think you need to remain objective and skeptical throughout all of this. That doesn't necessarily make sense on its face as a fact pattern, and that's something that investigation agencies and regulators are going to be all over. because that doesn't make sense on its face. Why would they need a cryptocurrency to obtain a government license or government approval? And as this fact pattern progresses, you need to be thinking about your loans on the UK export credit finance as well. So you need to be thinking about your contractual obligations under those documents, which I'm willing to bet contain certain reps and warranties, ongoing reps and warranties. It may be the case at this point that you need to reconsider whether or not you approach someone and self-report an issue. Because at this point, you've got an anonymous whistleblower out there, you've potentially had to make a disclosure to your lenders, and you have your local business unit, which seems to have more information than you have, and which presents an information leak risk. And at that point, you might say to yourself, well, things are looking a little bit more serious now. Do I want to make a virtue out of a necessity? If someone else is going to go and, file a SAR or make some other kind of report to a regulator, do I want to get in the door first and make sure that I retain credibility ultimately with any later investigation agency? This is an important moment in your kind of internal investigation where you need to reassess again what you know and the risks that might pose to your business going forward, even though you are distracted with your US acquisition.
Again, from a business perspective, I completely appreciate that there may well have regulators, but I also am very careful around the fact that a lot of the money that allows me to do the business, that allows Sparkle to conduct its business, comes from export credit finance agencies. Do I, in terms of thinking about talking to an outsider at this point, assuming we all agree that that would be a sensible thing to do, or indeed we may all say that it's still too early, but if we think that it's a good thing to do, would you advise, Louise, that I go and speak with the export finance agency first? Do I go and see them first because I want to make sure that that relationship is running nicely and there are no issues and that they appreciate we're looking into things? Can I do that in isolation? Do I need to think about knock-on effects of that?
I think you need to think about the knock-on effects of that. As soon as you go externally at all, you need to be thinking about the serious fraud office here. You need to be thinking about the US, to the extent you have a US issue here. And you need to be thinking about Turkey as well, because ultimately this is happening in Turkey. I would assume that at this point you've got a Turkish lawyer on the books as well, who's helping us out. But once you go external with this in any form, you need to make sure that you line things up in the right order so that it makes sense later. For example, if the Serious Fraud Office finds out that you've been talking to UK Export Finance and think you've got a real issue around this loan, they're going to want to know why you didn't come in and talk to them at the same time, at the very least, if not before.
And at this early stage, Rob, and we haven't sold yet into the United States, if I were to go to the UK Export Finance, if I were to go to the Serious Fraud Office, would I go to the DOJ at this point?
Well, once again, it depends on where you are in the underlying factual investigation. The lack of a clear and obvious U.S. nexus might counsel in favor of sitting tight. The investigation had concluded in its stage where all the facts are known and there is a lack of a clear and obvious U.S. nexus. Recognizing that the DOJ is fair and reasonable, I may well walk into the DOJ
Yeah.
apprise them of the relevant facts and explain that this is we're coming to an acquisition context. We, my client, my company, may have engaged in conduct that is problematic, but not jurisdictional. We're reporting to you in good faith, and we would ask you to do the right thing and decline the case.
There's a risk. Would you do it? Sorry to draw you in with you. No. So, if I were to go to the Serious Fraud Office now, with this information, because there are enough red flags, and we're talking about cooperation, we're talking about being in there first, even if you don't know the full story yet. From experience, Louise, would the Serious Fraud Office provide that information to the DOJ? We all accept there is no obvious nexus at the moment, but what if the Financial Times is reporting on the fact that there is this sale, and it's all looking like it's going to close any minute now? So the news outlets are picking up on it. Would the Serious Fraud Office pick up on something as subtle as that and discuss it with the DOJ, or would it think, do you know, I've got bigger fish to fry?
Not necessarily. I think the Intel unit at the Serious Fraud Office is pretty busy. I'm not sure they're reading the financial press every day and making links like that. I mean, it may be the case that they would. From experience, I think it's, we're still at a relatively low level in terms of red flag. You're not looking at some huge issue. So I wouldn't have thought so, but I'm no longer at the Serious Fraud Office, so they may disagree.
Things may have changed.
Exactly.
Please. We don't know yet. No. How are you going to find that out, Paul?
Well, I think just stepping back a bit, I'd urge a bit of caution before jumping the gun. People are saying there's red flags, there may be a need to report suspicious transactions. But actually, if you break it down and you look at each individual component, yes, there's been a whistleblowing allegation. We don't know whether it's credible. We don't know where it's come from. If you look at the individual aspects of what we know about what's happened, you've had upfront loans. Well, loans are often made. It may well be that was part of the rationale for obtaining financing from the Export Credit Guarantee Department. That may be totally above board and totally what was expected to happen. We've got the fact that the loans are repaid by supplying components. Well, that is a little bit unusual. It's not a standard transaction. But then we are operating in a region where I don't know what the banking system is like in Turkey and around there, but it may be that this is an efficient way of addressing cash flow considerations and maybe obtaining some kind of security from the customer for Sparkle to help facilitate its customer and supplier, Zarco, in setting up its facilities. It might be a very logical, rational arrangement. It might be that Sparkle does these kinds of arrangements all the time across its organization. It may have well-established corporate governance procedures and frameworks for dealing with this sort of situation. It may have analyzed the risks very, very carefully and made sure there's appropriate approvals and decision-making support across its business. The manufacturing under license, that's a totally standard process, nothing suspicious in itself about that. Now, against that, you can say there's definitely aspects that are consistent with a scenario whereby there is bribery or corruption or money laundering or fraud or collusion, any of those things. So definitely there's a scenario there, and there are risk factors which make you, which mean you need to investigate and find out more. But I wouldn't say that necessarily you're at a stage where you ought to be making suspicious activity reports to regulators or law enforcement bodies. One other risk factor I'd mention is that there does seem to be quite a close relationship here between Sparkle and Zarco. Zarco is both a customer and a supplier to Sparkle. Anytime you have a close relationship between parties like that, there is increased opportunity potentially for collusion or just for having lax controls because the parties are so comfortable and close to each other. But I would exercise caution before saying definitely this is, these are red flags and these warrant some kind of suspicious activity reporting.
So it does feel a little too early to step outside. Charles, would you agree with that?
Yes, yeah, I think based on the facts presented so far, I think we need to do more due diligence. As Paul said, you need to be at the stage for a suspicious activity report. You need to be at the stage where you have a reasonable suspicion of money laundering. So I'm not sure that we're at that point yet, but I think I think you'd be justified in holding off. But the facts as presented do potentially have these issues in there. But I think we need to do a bit more work, a bit more due diligence first.
Would you at this point consider or advise that the General Counsel talks more widely internally to discuss whether or not this is the right moment to go to the authorities?
Well, I'm not sure that you want to discuss it widely. I mean, back to the point I made at the beginning, with whistleblowing procedure, with whistleblowing, the most important thing is to protect the identity and the confidentiality of the whistleblower, and also to prevent any form of sort of recrimination or reprisal. But also, you don't want to jeopardise the potential investigation. So you don't want you don't want to go and talk to the people who are potentially going to be the subject of the investigation, because you might find documents disappearing quickly and/or people disappearing quickly. So I think you would keep it a very tight circle, and again, I would be looking at the procedures that you would have. But I would think that most places, the procedures would involve a small group of people, risk officer, general counsel, compliance head if you have it, investigative department head again if you have it, and possibly CEO on a sort of reporting basis. But I don't think you'd be going much more widely than that.
Would you establish that group from the outset?
Yes, absolutely. Yeah. And as I said, most big organizations will have procedures which do exactly that. They will specifically name the people who are to be involved at an early stage, and those people will obviously be subject to the usual rules around confidentiality and not sharing and so on and so forth, as well as the rules around not potentially trying to uncover details of who the whistleblower is and why they've blown the whistle, etc., etc. So I think it would be fairly standard for that to be a pretty tight group of people who would have been set right at the beginning.
And given that this panel will be followed up by a panel talking about the prosecution of this set of circumstances, let's talk a little bit about the evidence gathering that will be taking place. We have seen references to some conversations happening. The local manager has given some information. We've heard from a whistleblower. If I can divide it up between the obtaining of documents and the obtaining of witness evidence, Rob, would you take on the obtaining of witness evidence? How would you advise we take care of that in such a way that we generate information that could at some point be of use to a future prosecution?
Sure. Given recent guidance by the DOJ fraud section that hypothetical proffers of information to the DOJ is largely unuseful, what I would advise my client is to conduct internal investigations with multiple witnesses present and to obtain statements with an eye towards full disclosure to the government in an admissible and usable way. I would make sure to provide upjohn warnings to all employees, making clear that the statements they make to me on behalf of the company are, of course, privileged, but they can be disclosed at any time, and the privilege can be waived by the company if it so chooses. And the primary goal of the interviews would be, of course, to find out what happened, but also, to the extent it was in any way incriminatory, to potentially, with an eye towards disclosure, make those statements available to the government.
And Louise, from the UK perspective, we're interviewing people in Turkey. Would you arrange for some or all of the individuals to have independent Turkish legal advice lawyers? Would you add anything to what Rob has said in terms of how we would handle that information that we receive in the course of the investigation and how we would use it here in the UK?
Like, it's interesting hearing about witnesses, because certainly from my experience, witnesses don't get you very far. Witnesses don't tell you the truth. Even, in a Section 2 interview, witnesses don't tell the truth. I would focus on documents first. I'd focus on documents, and I would focus on the money. I think that's going to get you to a position where you truly understand what's happened in a more reliable and a quicker way than talking to witnesses. I would caution speaking too widely to witnesses as well at this point if you haven't gone to the authorities, because with each person you speak to, you're increasing the risk of a leak or of the media getting hold of the story. So I think this might be too early to speak to witnesses, in my view. But if you are going to go ahead and do it, then you need to consult with your Turkish counsel and find out what is the best way of proceeding on the ground there. It may be that employment law is very different there. It may be that they're entitled to different protections. We just don't know. But always ask the question: is it worth talking to witnesses at this point, or can we mine the documents a bit further here before making that call?
Or would you talk about documents in terms of mining them? One of course, but also, where do I start? What do I look for to begin with as my database from which I'm going to work?
I think what you need to do to start with is to understand the lie of the land, get a perspective on where do these transactions fit in within the corporate governance framework of the group. Are they standard, or is it the case that the Turkish subsidiary is off on a frolic of its own, it's doing its own kind of thing without the centre really understanding it and having the processes and procedures to govern that? So I'd start off by, at the centre, really understanding what is the corporate governance framework, and then drilling down, and then working out how does the operations of the subsidiary fit in within that. And then I would definitely look at individual documents, look at the loan files, look at the transaction records, look at the systems and controls around all the transactions and how the decisions were made and approved and how that was recorded. And really, it's almost recreating the transactions, transaction by transaction, to obtain more information about what actually happened, and that will throw out a lot of new insights. But secondly, to start forming a judgment as to how strong the controls are, whether the risks are properly being addressed and identified, whether there's appropriate segregation of duties between different people involved in the transactions. So really, you're starting to do a very in-depth trawl of the accounting records in relation to these particular transactions. Now, if you want to keep this away from individuals and avoid tipping them off, then that can be tricky, because how do you get hold of those records and understand the system without talking to the people who are operating it? That's something which would need to be discussed quite carefully, I think, with in-house counsel or external advisors.
Yeah, and I think another thing to think about is at some point, once this becomes more public or more known within the organisation, you need to think about the timing of sending out some sort of document preservation notice to employees. I think if you were to do that at this point, that would set hairs running and put people on notice pretty quickly. But at the same time, that really, I think, is a judgment call as to when you send that out, because at some point you do need to put people on notice that all documentation, including emails in connection with this transactional set of circumstances, must be preserved and must be maintained and not sort of removed for any reason. Even though I think it's pretty hard to actually to really fully delete emails, it's the sort of thing that makes life very difficult if people have tried to do so. So I think that timing of that preservation notice is quite tricky, because on the one hand you would not be sending it out at this point, but I think if you did establish that there was a really credible case, I think at that point you probably would need to think about doing that.
I think that's a very good point, but I would say there is an intermediate point you can take. So the preservation notice will have to be given at some point, presumably if the investigations go down that path. Yeah. But before that happens, a lot of information, most information these days is held electronically. There are backups. You need to talk to the central IT department and function to find out, are there ways to, in effect, clone and capture and preserve information behind the scenes without alerting the users to the fact that that's being done. Yeah. It still doesn't deal with paper documents or systems which are off the main corporate systems and not being backed up or not accessible, but it does give you quite a lot of protection and the ability to come back later if you need to. Yeah. Trying to retrace what's happened.
So at the moment, both Rob and Louise are on site. All of the information is retained either on the server, wherever that server is. We haven't quite figured that one out because our IT structure is a little complicated. But all the documents and all the documents that are being generated are at the moment still in Turkey. If I'd say to you, Rob or Louise, if I'd say, actually, I'd like you to send me now from Turkey your hot emails, your hot documents, the key contracts, everything that you found that I should now look at so that we can decide whether or not we need to report and who we need to report to. Without this becoming a data protection panel, because that is typically a panel worthy all of its own, there are obvious issues at that point, are there not? How do I deal with that? Louise, if I can start with you.
Yeah, you just need to get Turkish legal advice on that. None of us here, well, maybe some of us here are experts on Turkish data protection law, but I'm certainly not. And if that's where your evidence is, you need to make sure that if you're getting that and if you're moving it, you're not doing it in a way that's going to create liability issues for you of a whole separate nature. You've got enough to worry about, frankly, without getting involved in a dispute over privacy rights or data protection in Turkey.
And if at this point we were to say that we ought to speak to either the export finance agency or agencies or the serious fraud office, or indeed have that friendly chat at the DOJ, and they ask us, well, can we just see your hot documents? Can we just have a bit of an idea of what contract you're talking about? Is there an overriding premise there? Do I at that point, I am actually looking at you again, Louise, because my first instincts are still going to the SFO. I'm still not all that sure about what I need to do in the US. But if I were to go to the SFO and they say, well, give me some documents, and I say, yeah, they're in Turkey, what's the response I'm going to get?
And we can't get them out of there, and yeah. And
Well,
there's-
say we
there's
can't
some-
get them out of there without the consent of the custodians. What is then the response that I'm likely to get from your experience?
The response you're likely to get is, well, you need to figure out a way to get them, please. Because ultimately, if your liability is in the UK, and that's where your risk is, you need to try and work out a way of getting the authorities comfortable that you are a sort of credible candidate for cooperation. If you're looking down the road and you're looking at DPAs and all that kind of thing, the last thing you want to do is to be trying to create obstacles where there may not be one. Now, if you are in a situation where it's illegal in Turkey to export these documents at all, then that's a conversation that has to be had, and you can be pretty robust about that. You don't want to be breaking the law in one country in order to create a better legal situation for yourself in another. And that's a conversation that you need to have, and that hopefully the authorities will be sympathetic to. And there are always ways and means around these things. The SFO does go overseas from time to time, and it may be that it could be accommodated in that way. So it's a conversation you need to have, and it does put a company in a difficult situation. But if you can show that you are credible and you're trying to do the right thing, I don't think it needs to escalate into some kind of huge dispute.
Could I ask a question? I'm on the panel, but I wanted to ask a question of Rob.
Sure. I'm your U.S. counsel.
Exactly, yeah. So what is the position of the DOJ in circumstances where you have that sort of conflict of laws? So if we were in DOJ investigation territory, but let's say the Turkish rules, and again, this is all hypothetical, do provide that, without the consent of the individuals, you're not allowed to export the information. What would be the approach of the DOJ in that
Sure,
case?
I could advise you that the DOJ could do one of two things. One of three things. Ask the company, notwithstanding the ability of foreign law, to provide it the documents. Oftentimes, the DOJ's experience, having been a former DOJ attorney now in private practice, oftentimes the response is no. So the DOJ has two other options. The first option is to seek approval for and obtain something called a Bank of Nova Scotia subpoena, which would be served on any entity operations in the States, compelling the company to produce all documents within its possession, custody, and control, no matter where they are in the world, and seek an order to enforce that if the company says no. And the third thing, and most extreme, the DOJ could do is resort to the MLAT process. Obtain an MLAT in the States, have it served on the foreign sovereign, and ask and request the foreign sovereign to execute a search warrant to obtain the relevant materials and documents, which would in turn be provided from the foreign sovereign to the States. So those are the three
So that's
ways in which to get the
regulatory regulatory cooperation with the relevant authorities in the local country.
With respect to the third, yes.
Yeah.
And if it's more of an informal conversation at this point, so you don't want to deploy all those more formal routes at the moment.
I would advise my client to absolutely walk this into the DOJ so they could get the documents as quickly as possible.
So can I ask a question on that?
Please.
So I apologize. I know you did solicit questions, but I'm curious about this, particularly from Louise and Rob and the other important prosecutors and litigators. So I would never. I would want what you set up here. I would want my client to say, look, we should report this, and I would want to instruct the client legal advice as an investigator not to report this, because my main concern as an investigator is talking to whoever might have made this potential bribe before that, and a lot of you have mentioned this, before that person knows that we know, right? So here's my question to the regulators, the prosecutors, is would you hold that against, if that was how it was set up, if we could walk in down the road after we knew the facts and say, look, the client wanted to walk this in, I told them not to for investigative reasons. Based on this scenario, I would never, my advice was never to be interacting with the regulators or the prosecutor's office at this point. I just think it's too dangerous. Would that be held against us? I don't want to put anyone on the spot.
So the fact that you've gone out and done your own investigation.
Well, no, that I actually stopped
The client
based
from
on
going
my
in.
advice, my legal advice as outside
Okay.
counsel. I would say, no, we're not going in yet. We need to know the facts.
Yeah.
We're blind here. And so, and I want to talk to this figure out who the person was that potentially gave this cryptocurrency to somebody in the Turkish government. I want to know that fact before I'm sitting with Rob or Louise or anyone else. My question is that your government, put your government hat back on, please. with your government hat on, is that something that you would hold against my client if when down the road we probably with a scenario we'd walk in and say, look, this is what happened, this is what we figured out.
Yeah, I'll give you an answer, and I don't mean to be cute. It's the truth. It wouldn't be held against you, but if you cooperated early and provided meaningful assistance in the form of allowing the government access to folks, you would get more in the way of cooperation credit, which may guide the relevant analysis in terms of what disposition is appropriate or what monetary penalty, if any, is appropriate. So although it wouldn't be held against you, like any cooperating witness, the more they do, the earlier they do it, and the better the evidence obtained by them is, the more credit that cooperating witness gets, and in this case, cooperating entity would receive. That would be based on my previous experience in the DOJ, not experience as corporate counsel.
Do you see that happening though, Rob? Do you see people walking in while they're in the middle of an internal investigation, kind of working in partnership with you? Is that something that
It happens.
Yeah, that happens.
And talking now again from what I have the most experience of, which is financial regulators, that absolutely is encouraged and probably would be held against you if you delayed disclosure for too long. And there are many cases of enforcement action which have been taken against firms for failure to disclose at an early stage, and even if those are not necessarily always public censures, but there is plenty of evidence or plenty of examples of people being slow to disclose, and that is absolutely not what the regulators are encouraging. They would rather you come to them and say, we have unearthed these potential facts, we are doing our own investigation, we will report to you within X number of days or weeks on the facts that, as we uncover them, but we want to give you an early heads up. That's very much encouraged, and the rules that many regulators have are sufficiently woolly here in terms of how they're defined, i.e. regulator would expect to be informed of anything which might be material or which you would reasonably expect the regulator to want to know about. So they're very hard to be totally objective about when the timing is, but certainly I think early disclosure is something that any regulator would absolutely encourage.
Louise?
Yeah, I don't disagree with any of that. I agree with it.
I think it's a really interesting point of what I'm hearing, but I don't know if I'm just hearing because that's my experience and that's why I'm hearing it again. That if you were to go to the SFO with an investigation that has pretty much run its course and that you have all the answers already, whereas there are identifiable points earlier on that says, well, actually at that point, at that stage, you knew that there were concerns about how business permits were obtained. Why didn't you come to us then? At that point, you obtained that piece of evidence that gave you this bit of information. Why didn't you come to us then? And if I were to respond to that, and I am actually going to put this also as a question in a moment, but if I were to respond to that saying, well, actually, I needed to go the full circle because I wanted to be able to advise my client fully before going in, or I wanted to be able to come to you with a full picture, I think I'd be shown the door. And I don't think it would work well for the client. In the UK, I've got the feeling slightly that in the US that is slightly less badly received and more accepted. But am I misunderstanding what my experience is here in the UK, Louise?
I think if you come in with a nice glossy investigation report, we've done this, we've got all the answers, we're done here, but we're just letting you have it. It doesn't go down too well most of the time. In my experience at the SFO, I can't remember any investigation report we received in those circumstances to have been accepted, put it that way. We always went back and did our own investigation anyway, and often came to different conclusions. So it can be dangerous. It can be dangerous sometimes to do that. But again, it's not necessarily going to be held against you unless you are really looking for something like a DPA or extra credit. Here in the UK, it's obviously always an option. You decide when you think the timing is right, and it all depends on what your risk appetite is and the sort of culture of the organisation. There's a lot of things that play into that.
I think this picks up on one of the important points that Paul made about having a sort of decision log and a fact gathering log. because you need to be asking yourself this question on an ongoing basis. And if you're continuing to say, well, we don't think that the disclosure is appropriate at this point, you need to be able to explain why you were taking that decision at that point, because you will certainly be asked.
Thank you.
Anyone else?
Is there a tension between the US and the UK in terms of interviewing witnesses without involving the prosecuting department still? I always got the impression that the SFO and the DOJ had very different views on coming to them with interviews, etc.
Yeah.
Does that remain?
I'm not sure about the differences necessarily. I think there is probably a small tension there. I know sometimes, we say don't go and talk to the witnesses, or we, in my previous life, don't go and talk to the witnesses, we want to do that. And the DOJ are on the other side saying you must go and talk to the witnesses because we want you to report on it. So I think that tension's still there.
How do you resolve it in a practical
just
setting?
to answer your question specifically, and then answer yours, Chris, the tension right now is that when the SFO and the DOJ, or the DOJ and the FCA, conduct interviews together in the same room, there is case law in the states that suggests, that holds, that for purposes at least of that interview, and perhaps more, the investigation becomes joint. Once an investigation becomes joint, all the SFO's stuff, communications, decision-making, thoughts and impressions, those materials become ours for disclosure purposes. And so we may be under an obligation to disclose those materials to a court in the event of a prosecution. And the SFO rightly says, well, shoot, we don't want to give it to you. This is our own internal stuff. And so we're in the position of, if there is a joint investigation, the SFO says, we're not going to give you access to all of our stuff, not bringing the case, because we simply can't satisfy our discovery and disclosure obligations. So that is one of the primary tensions.
And in terms of resolving it on a practical level?
I think we rely on the professionalism of the men and women at the DOJ and the professionalism of the men and women at the SFO. We can work through these issues. We have successfully, and it's only gotten better over time as we've worked together. So, have there been hiccups? Yes, but I'm happy to say that it's gotten a lot better, and it's going very well.
Christine, if I could ask a question.
Please.
As moderating the next panel. But Louise, what about the situation here is obviously difficult because there's a sense that being in Turkey, having access to witnesses or even documents is very difficult, or that if things became overt, then both witnesses and documents can vanish. But that applies as much to the SFO as it does to the company, and it seems unlikely that the authority would be able to be any more delicate with the company. If someone did come in early, as you said, and instead of waiting for there to be this glossy package, what would the expectations be of the company then trying to make things happen with the SFO? It just seems it would be the same difficulty for the SFO that it would be for.
Yeah, I'm not. No,
Christine
and I don't disagree with that. And actually, sometimes if it's possible for the company to go out and get those documents in a kind of forensically sound way, I think the SFO would thank you for that. If they can be handed over intact, and in a way that's forensically sound, then the SFO would be very grateful. Witnesses probably less so, just because. If you're willing to divulge first accounts, then great. But just sometimes, as I said before, with witnesses, the first shot is often the most. That first conversation is often the most important, and I think the SFO would normally like to have that first conversation, just because the evidence of witnesses is so often unreliable in these investigations, depending on the questions they're asked and the circumstances in which they're asked them.
If we just stay with your theme, though, and again looking ahead at the next panel, just assuming for a moment that we feel uncomfortable enough with what we've unearthed, that we have been talking to the SFO, to the UK Export Finance Agency, to the DOJ, what would the expectations be on the company to provide information materials that is of evidential value so that you may then can go ahead and prosecute? And how does it benefit the company to do that so to gather the information and the evidence in such a way that it gives you more than just intelligence? What's the expectation and what do we get in return? Shall I start with the DOJ?
Sure. As a threshold matter, based on the facts of this case, I would advise my client that given the lack of a clear and obvious U.S. nexus, the DOJ would likely defer to its friends and colleagues at the SFO to take primacy over the case. If the case was ceded to the states for whatever reason, there would be significant cooperation credit given to the entity, the company, in the event the information was provided in a usable way at trial. Information that is usable from an evidentiary perspective in trial is much more valuable than information that is given that can only be used, for example, derivatively. So the company would get enhanced cooperation credit because of the way in which it produced the information, and that would shake out to the benefit of the company in terms of the form of the resolution potentially and the extent, if any, of the monetary penalty.
Is that the same in the UK?
Yes, to the extent you can save the taxpayer money by providing evidence and by going out and conducting inquiries, in cooperation, I suppose, with the SFO and responding to their kind of leads and their ideas, that all really helps when it comes to a discussion around, DPAs or credit or whatever it might be. Anything you do will be noted and will be appreciated.
Paul, how do I tackle that then practically? So as we go through the investigation and a lot of material is generated, how do I create that in such a way that we all stay on top of what we've got, but we also have that eye on the ultimate prize of whether it's the DPA, whether it is an NPA, with any way of getting the company to clear up as quickly as possible and get on with the sale. How do I deal with that?
Yeah, I think it comes back to the process and the decision-making framework that you put in place for the investigation, which is both a process for helping guide you through what decisions to make and how to develop your work plan, but also becomes a record with a continual snapshot at any given point in time as to where you were and what was the information you knew at the time when you made each decision. So you have your issues log, which is your known unknowns, which has all the potential bad outcomes that you think might occur, and you carefully document it. You tie it into the information and evidence that you've been reviewing, and you separately have your case file, which contains your decisions. So at any given point in time, you can say, I made this decision to drop the investigation into money laundering, because I thought there wasn't enough evidence based on this information. And if you have your information system structured appropriately, you can evidence it. You've got a file you can present if you're challenged on it later. It says, this is the basis for my decisions. I have decided not to self-report to the SFO on the basis of these documents and this analysis of those documents. And our judgment, taken honestly with due diligence, was that there was no need to report.
And cross-referencing the documents.
All cross-reference.
Yes, exactly.
Yeah, that's the point.
Well, let's think a bit more about documents. Some further investigation reveals that there is limited documentation by local staff of SACCO's reasons for the arrangements and relatively sparse records of Sparkle's due diligence procedures. And the transactions had been signed off by compliance, but based on incomplete information. At the moment, it looks like weak compliance function at local level, at the best. A deliberate non-recording of important corporate events.
Potentially, yeah.
What do I do with this?
This is a fact that would be quite worrying from an SFO perspective, especially if you're looking at a Section 7, so the corporate criminal liability element. Because if you've got a compliance department who doesn't have, if you don't have adequate procedures in place, you're already on the back foot. And if compliance have been signing things off based on incomplete information in this scenario, what else may they have been signing off? And this is what the authorities will be thinking. And this is potentially a kind of dangerous moment for your investigation where it might go a lot wider than this narrow fact pattern. It may turn into almost an investigation of your compliance function, and that's something that you need to get a handle on very quickly. And if compliance are involved in your investigation already, query the extent to which they remain involved if there's a chance that either they've been complicit or negligent in terms of carrying out their own function. So this is a moment where I'd be quite worried as a GC.
And I think one of the things you need to think about here is perhaps not just on the compliance side, but also given that we've got sparse records and so on, you might be thinking about local finance department as well. But you need to be thinking at some point about whether or not it's appropriate to suspend any of the employees, because if you've seen evidence of complicity or gross negligence, then you might very well want to take a view that actually having these people off-site is preferable, because then they would have their access to systems suspended, and it would prevent any kind of tampering and so on. So it's always, as part of these investigations, the appropriate moment to consider suspension of staff and suspension of access to systems. Importantly, that's a very important point to think about during this process as well.
And would you think that this is now the moment to issue that document halt notice, or would you have done it earlier?
Well, I think it sounds like now you've unearthed something that's got more than just a whiff of impropriety. So, and it sounds also that presumably a number of people have been engaged in the process internally. So the cat's out of the bag to some extent. So I think probably you're thinking it probably would be the time to start thinking about a document retention notice. Absolutely, and as soon as, of course, as if you were to take the step of suspending any employee from employment, then that becomes pretty well known pretty quickly. So this will also potentially accelerate any external disclosures you might have as well. We go back to the listing rules, which I mentioned at the beginning. We've got, at some point, you've got listing disclosure obligations to make, and again, once things start to become more public, then you need to be thinking about that as well.
So it seems now that we are reaching a bit of a crux moment.
Mm-hmm.
The moment where you might consider suspending employees, would you ever do that in isolation of talking to a regulator? Because, of course, you immediately enhance your whistleblowing risks by putting people out of the business. Would you typically tie that all together as you are considering and discussing whether or not to self-report?
Yes. The short answer is yes. I think if you're at the moment where you're suspending someone on the basis of this particular fact pattern, you need to be thinking, if you haven't already approached someone externally, you need to be doing it at that moment. I think the two go hand in hand, really.
Yeah, I think it would be unlikely that you would have taken the step of suspending somebody without also having informed relevant regulators, because that's quite a significant step to take, and I think at that point you're basically flagging that you've got a real concern, in which case your duty of disclosure has taken up a level.
Rob, would you agree with that?
Well, look, I would remind you as my client that there's a pending acquisition by a U.S. entity, and that U.S. entity is going to surely do their own due diligence and will likely discover this. So I would advise you quickly to figure out how extensive and systemic this problem is, quickly, responsibly, and once that problem is properly assessed, to remediate as fast as possible, both to ensure that the deal goes through and to be able to go to the government, either at the SFO or the DOJ, and say that remediation efforts have been undertaken and enacted.
Because that raises a different issue altogether, doesn't it? At which point, before or after going to the regulators, at which point during this scenario as it's developed, would I have spoken to the potential purchaser and mentioned the issue that is going on? At which point do you do that? Again, you increase the likelihood of people reporting, you increase the likelihood of the thing escalating. I may lose control of the investigation if the purchaser is so deep down in the company already that it wants to run it for me. How do you manage
Failure
that
to give
practically?
fulsome and robust disclosure to an entity that ultimately acquires you as my client could be problematic. It could be the basis for fraud. So I would again get my arms around the issue, see how systemic it is, and make fulsome and fair disclosures as promptly as possible.
Let's go a little deeper again. From your conversations in Turkey, it seems that it should have been clear to the local staff that there was a risk that Sacco would be unable to repay the loans which were recorded, of course, in Sparkle's books as being fully recoverable. Important again for the sale, important again for the accounting issues that arise. And indeed, even after the price of the silk coins plummeted. This wasn't communicated to compliance at the time. And had the loans been fully written down, Sparkle would have breached its loan covenants. It may also have breached the conditions of the export loans and related grants and tax credits. So I think my problems have gotten even more extensive now. And I am now properly worried about the outstanding relationships that Sparkle has with export credit finance entities. As well as, of course, the increased risk now in relation to the SFO and the DOJ. Sticking with the accounting side of this, Paul, what would you advise at this point?
Well, I think what it raises is the point that we don't actually know very much at this stage about what's happened to the silk coins. So we've been told that the loans were made to Zarco using silk coins. There may be documentation internally as to what the intention was going to be. You know, why did Zarco want silk coins and how was it going to deal with them? We don't know if the loans are still held as silk coins. And it raises a very interesting and perhaps difficult question about how much should we be talking to Zarco about what's happened. People who were here yesterday and heard the blockchain and cryptocurrency session will be aware that every cryptocurrency, such as Silk Purse, will have an open ledger. Every single transaction in Silk coins will be recorded in a ledger, and that will be auditable. So what's happened to the payments made by Sparkle will be recorded on that ledger. Now, if it were the case that it was appropriate to cooperate with Zarco and obtain, to work together with them, and if they said, well, this is totally above board, there were no bribery payments, we paid the money on to our own suppliers, or whatever the story is, whatever they say should be quite easy to verify. Yes, the ledger is open, but it's going to be anonymized, so you won't see immediately who are the wallet holders, who owns each account. But if you've got cooperation from Zarco, then they can say, well, this is my account, we can prove it, we can show the money coming in, and we can show what's happened to that money since. And if they're saying we've paid it on to these suppliers, then they can say, well, these anonymous accounts or wallets represent these other suppliers, and you can almost very quickly close the whole investigation. That's one avenue for demonstrating that actually the allegations were false, and there's no problem, it's a storm in a teacup. That does raise questions, of course, about tipping off and whether it's appropriate to raise this issue.
To even talk to Zarco.
To talk to Zarco.
And then on the assumption that they talk to us, which is...
Yeah, and it's another question, we don't know, is Silk Purse a reputable cryptocurrency, or is it something that's dubious? I mean, the name sounds dubious, Silk Road and all that, but maybe here's a time to start talking to law enforcement and get their involvement and ask them for permission. Should we be talking to Zarco? Is this something that perhaps law enforcement should take over and look at? We don't know at this stage. We don't know what due diligence was done by the company, and we don't know what law enforcement might know about the cryptocurrency and whether it's something that's going to raise alarm bells.
Could I ask you, because you asked the question earlier, would you mind?
Not at all.
Would you at this point still stay with, we will investigate all of this, we won't go to the authorities just yet until I have the complete picture? Or is this perhaps a moment where in your own thinking you may now bring in the DOJ or the SFO's guidance?
Well, let me claim a weakness with the serious fraud office. That's not where I operate. But with DOJ, I got to confess that I would never even think about going in yet. I would want to know, I would want to interview the people there and see you looking at me.
That was a quick turn of the head, I thought.
I would want to interview the people there and know and talk to you about what the exposure was. But the main reason down the road, if people, my former colleagues at DOJ, were yelling at me for not bringing it in early, would be, look, this is on me, it's not on my client. And as an investigator, I wanted to know what these people, before we started doing hold notices and all that, I would want to hit these people while, if we can get them while they're cold, and get an impression of whether they're bad actors, which we clearly are at this point, and give you advice on who we're going to fire before we walk it in. You're my client, not the employees. So I would not, I think Kirby bears with me on this. I would,
We'll move on to you very quickly now.
so I would not even think about going in yet, but I would really be running as fast as I could to get those interviews done, possibly even doing it, and I know this is against
even though we hear today that the Serious Fraud Office doesn't think much of
No,
interviews.
that's not the Serious Fraud Office, that's me.
Louise doesn't think much of the Serious Fraud Office. Oh, that's a simple time.
Yeah.
Doesn't think much of
Interviews.
the value of interviews.
Right, and again, I have a weakness there. That's not where I practice, and so it sounds like there's a little bit of a difference in terms of practice here than at least my experience with
Yeah, no, these are my personal views only to the extent
My fault.
relevant.
My fault
I'm
entirely.
actually speaking for the Justice Department.
Well, actually, on that note, would anyone here from the Justice Department care to comment?
Yeah, sure, I can.
Very safe. Please.
First, the notion that the company can divorce itself from the actions of counsel is not consistent with practice. At the end of the day, the client is in control, and the client, I'm guessing, based on full disclosure of facts by counsel, decides the course of action. So I don't think it would be entirely defensible for counsel to come in and fall on the sword and somehow exonerate the client for a strategic decision. The second thing I would say is I completely understand and recognize that the best way to get information accurately is to go to witnesses cold, which is precisely why we want to do it instead of you. So again, understand it, makes total sense, but you can't fault us for not giving you as much cooperation credit if you don't let us do it first. Same reason you want to do it first. So those would be my 2 points.
Right, but in this case, the DOJ, there really is a jurisdiction issue. I totally agree with Bill. And why would I go to DOJ at this point? Even though it does look like there's a problem to Turkey, acquisition hadn't happened. So if I've got, I don't know, I'm with Bill. I haven't dealt a lot with the SFO, but okay, I make that analysis, but I'm not thinking about the DOJ. I don't know enough.
I
Gentlemen,
suppose that the facts, Sandy, are twisted a little bit. And I may be talking about this.
Are you going to do that, Mike?
Well, what if the head of compliance turns out to actually be a U.S. citizen working for the company in Turkey? And what if the evidence turns out, at least plausibly, right?
What?
Right.
Then the company has potential liability under DD2 of the FCPA.
And that could change the entire analysis of what the company needs to make. And it certainly will affect ultimately how to enforcement.
And of the sales pending the way it's described. I mean, it makes no sense to disclose it to the purchaser and not disclose it to the DOJ. So
Yeah.
it seems to me that those two things fit together. So really, part of it is that what's really driving it?
Yeah.
So I really need to know more.
Yeah. Well, that's an excellent point because a lot of entities who are successors do, as soon as they get disclosures like that, walk in pretty quickly to get in front of the issue and to give their client comfort that there may well not be an enforcement action.
Isn't it possible that the company has SFO, whether the company should also go to the DOJ? In case that SFO is asking that sort of a question from the particular company, then the seller is in the position to advise, you should also go to DOJ.
The SFO isn't going to advise on U.S. law. No, that'll be a decision for the company.
So the company must decide.
Yeah.
Well, can I just add, I mean, his point is a good one, because there is a consideration that we would take, we certainly would take into account for DOJ if we thought that the company was being selective about its disclosures in order to be unshot for some reason, because the reality is that if something that we see that involves equities with another company, we're very likely to involve them or at least let them know about it, whether they want to pursue it or not. So I agree with Louise, we wouldn't provide legal advice, certainly per se, to any company, but they would be on notice if there's some reason that we think that they disclose in a particular jurisdiction to try to wrap it up there in hopes that they, whatever other country, including the U.S., might be an afterthought that they wouldn't have to deal with, that would not go well for the company later when we do have to deal with it.
Or I've also seen companies under investigation tactically report to as many different authorities as they can, just in the hope that it'll get a bit confused, and that'll buy them some time. So, that's also a tactic that can be considered. Not one I'd necessarily recommend, but it's something that has been done before.
Please.
Just a question, maybe Louise, you're best answer it now, but is there a possibility that by reporting to the SFO will then still have the conversation?
Yeah, absolutely. If there's a nexus, then yeah, absolutely.
And I think that is a very heightened consideration in financial regulator circumstance, which we're not in here, but if you were, that definitely is more of a real risk.
Please, Clive.
I just wonder whether this development in the book starts to unwind, because if the loans need to be written down, that's what I think I'm reading, and
Mhm.
like the agreement with the loan company, it might just be financial disclosure at this point will not be very quickly.
Yeah.
Yeah.
So what are these sort of deliberations about? Would you like to know more? I'm not sure those options are available now.
Yeah, if you're about to have your financial rug pulled from under you, you have to go to the market at that point, you know. And the other thing to bear in mind is, you know, this is a situation where maybe the loans haven't been fully written down yet, but you're kind of waiting to see, are you going to be repaid? And if you are going to be repaid, you know, are you going to be repaid by Zacco, who, you know, you don't know what they've done with that money.
Or through sale coins,
And
the
you know-
value has plummeted.
Yes, and we heard, you know, Sandra and Lisa talking yesterday about money laundering, and in a situation where you're not talking about historic conduct, but you're talking about conduct that's potentially ongoing right now. If there's a money laundering button to be pressed, the authorities are going to press it, and they're going to press it quite hard, and they'll use that to bring pressure on the company to bring them to heel. So at this point, yeah, you're in a very dangerous situation, both with your, you know, in terms of your own financial position, but also potentially from a money laundering perspective.
And I would add, to the extent these might not be loans, right? They could be bribes, in which case it doesn't matter if they're written down or not. They're improperly booked as loans when they're bribes. If that is the case, then the company, it would appear to have falsified books and records. And I would hope, for my client's sake, that those financial statements did not go to any XM bank in the States that would have provided financing based on those falsified financial statements, because that could expose my client to, of course, allegations of bank fraud. So this is, if the underlying payments are in fact bribes, the mere fact that they have been booked as loans is a per se problem to the client, I would think.
Well, it seems that with that, we've reached our time, and we've left you with plenty of facts to deliberate for the next panel, I'd hope. I'm very pleased that we'll be swapping places now, because the real tricky bit is happening now. Thank you all very much, and a huge thank you to the panel.